How's that for an impromptu live, my friends? Is there anybody out there? Just not if you can hear me. Is there anyone home? They back. The jury has said that they are unable to come to a verdict. They're deadlocked. It's only been 5.5 hours. And here we are. So here's what happened. I'm waiting for some people to get in. Of course, the prosecution wants an Allen charge. Jury's only been out for 5.5 hours. They had one question earlier today, and they wanted to know about Dr. Quintal's testimony. So I figure while we're here, if everybody comes in, we'll go back and we're going to watch Dr. Quintal's testimony. That will take us to the question the answer to the first question that the jury came back with earlier. You guys have probably been watching it the whole time, just like I have. The jury has come back to say that they are deadlocked. We are unable to reach a unanimous verdict. And they've only been deliberating for 5.5 hours. It is currently 9:48 p.m. on the East Coast, which is where we are and where Florida is. And they have been out for 5.5 hours. They got pizza, they got soda. And I thought they'd be close to a verdict because, trust me, you're not sticking around for Florida pizza unless you're getting close, in my own opinion. In my own opinion. And so so we'll go back to the first question after this because, I've been just hanging out, waiting to see what would happen. So the jury sent a note out to say that they are unable to come to a unanimous decision and said to the attorneys, the judge said, "Okay, what do you want to do?" And of course, Mr. Taylor looks at the judge and goes, what do you mean? It's been like only 5.5 hours. Send him back or let him go home and come tomorrow." And the prosecution says, "We want an Allen charge." And Mr. Taylor says, "An Allen? It's been 5.5 hours. That's like a last ditch effort." Yeah, right, absolutely. 6 hours is way too quick for an Allen charge, in my opinion. We saw an Allen charge in the Karen Reed case, and it took a while to get the Allen charge. We'll look at the Allen charge in Florida after this. He did not give them the Allen charge. He said, or they're going to come back and he's going to tell them, "You can go back in. Let me know if you want to go home." Let's take it back a little bit since you're all just joining and you might not have been here for the beginning of it. Or you might not have seen it on your own. So I'm going to play it back to you. Here's what happened. They said jury has a question, and they all came in. I love how the judge has a screen. He can just look up. He looked like do you think he was sleeping on the couch in his office? All right, everybody came in.
All right, welcome back, everyone. We're back on the record in State of Florida versus Atty Benefield, 2020 CF 3014. I have another communication from the jury. I'm going to read it verbatim, and then I'll hear from both sides. Unable to come to unanimous verdict. Signed, juror.
That's an easy one. It's been less than 6 hours. Keep working. But with this caveat, Your Honor, I think you should at least acknowledge to them, because I don't know that either out of politeness or a sense of intimidation, I don't know that they know they can ask if they can go home and come back in the morning.
Judge, and I think asking them about going home and coming back is definitely something that they also need to Allen charge before we make any decisions after that.
How do you give an Allen charge after 6 hours?
Yeah. Well, just go ahead and say your piece.
You don't give an Allen charge after 6 hours.
Judge, I didn't realize that there was any hour attached. to an Allen charge. I just thought that once they said they were deadlocked, that you give them the Allen charge.
Is this your first
But-
trial, ma'am? Is this your first criminal trial where a jury hasn't been able to reach a unanimous decision in 6 hours and they stuck around for Florida pizza? Really? So you want to give them the Allen charge? Because you can only give it once. We'll go over what it is if you don't know what it is. But if you watch the Karen Reed trial, you know what an Allen charge is. It's also called a dynamite charge. But she wants it right away.
It's almost 10 o'clock, so they may want to go home and come back tomorrow.
All right, thank you both very much. As we all know, the Allen charge is a one-time thing. So my inclination was to bring them out, acknowledge that they've been working for almost 6 hours, well over 5.5 hours, acknowledge the time of the evening, and give them that option. And I'm not going to ask for them to vote. The way I do this is I'll explain to them, you've been working, we acknowledge that, it's late. If you want, you can go home for the evening, come back tomorrow, fresh, and continue your deliberations. I send them back to decide if that's what they want to do or not, and then go from there.
Yes, sir.
Okay?
Okay.
All right, let's bring them out.
Okay, so they're going to bring the jury back in. It's kind of where we left off, I think.
Members of the jury, I've received a note from you. It says unable to come to unanimous verdict. We all recognize that you've been working for almost 6 full hours, and it's getting late. It's almost 10 o'clock in the evening. I want you to go back, and there's an option that we can come back tomorrow and start fresh in the morning. I do have some court first thing in the morning, but we can get started same as every other day about 9 o'clock. So I'm going to ask you to step in the back and make a decision amongst yourselves if you'd like to come back tomorrow morning fresh to start.
Or there's no other option.
I need you to discuss that first, please.
Okay, so it's almost 10 p.m. Do you know where your children are? Somebody said it was I just highlighted a comment that said it's 3-3. We have no idea what the split is. We're not going to know the split. It could be one person holding out. We'd have no idea. There's nothing worse than waiting for a verdict. It's just the worst.
We'll be in recess until all right. The response from the jury is we will stay.
We will
Signed
stay.
by a juror.
They're going to stay. Maybe they're close. I mean, it's 10 p.m. How long are they going to stay?
So we'll be in recess until we get another question or a verdict.
Yes, sir. Thank you.
Yeah, just going to pull an all-nighter? They busting out the no-dos? Busting out the no-dos like a bunch of college students? I mean, they're staying? I mean, these guys are hardcore, huh? These guys are hardcore. They are staying. Wow. The waiting is the hardest part, said Tom Petty. Only 6 in a criminal jury in Florida unless it's a death penalty case. This is not a death penalty case. That is why there's only 6 jurors. Send them home to sleep on it. I know I would send them home to sleep on it too. Come back fresh in the morning. Right? That's what I say, Jen. But, nobody asked me or you, apparently. But they're staying. They're pulling it out. They're going hardcore. There was an earlier question this evening, so while we're here, we might as well go back and look at that as well. And that is Kubi. That is why there are only 6 jurors. This is Florida. 6 jurors in a criminal case unless it's a death penalty case. That is why. And look at that. I pulled up your question before it was even a super chat. Thanks on top for being on top of 2 super stickers this evening. All right. The question earlier today. Let me pull that up for you. And I was gonna go live, and then I was like, let's just see what the question is first. Thanks, Steph, for becoming a new member. So here is what happened earlier. Let me say. I was just rewatching that rebuttal. I was watching my own stream because I'm verklempt. I'm verklempt about it. Let me get to the spot. Hold on for 1 second, because I don't know if I'm even at the right spot. Where's the question? So this was after they had been deliberating, I believe, for only about an hour and 46 minutes. They had a question about Dr. Quintal's testimony. This was from earlier today.
All right, welcome back. You're back on the record in State versus Benefield, 2020 CF 3014. And you've been called back because there's a jury question. And I'm going to read the question, and if either side wants to approach and look at it yourselves, you sure can. I'm going to read it as it is. Dr. Quintella testimony. Defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e., domineering, super controlling, alpha male, over the top, not genuine?
So the jury wanted to know earlier today, after 1 hour and 47 minutes of deliberations, whether Dr. Quintal's recall testimony, and that is when the defense recalled Dr. Quintal during their case in chief, whether the things that he said about Doug being controlling and alpha male, whatever things they just listed, was that the doctor's opinion based on things that Ashley told him, or was that the doctor's opinion? So here's how they argued this, how to handle this question. And I'm going to tell you that I disagree. So just be prepared for my disagreement.
First?
Any particular order?
No, sir.
I understand the question. What's the court's inquiry?
How do you, I'm listening for, I mean, I know in my mind how I think I'm going to respond, but I'm always going to give the parties an opportunity to be heard on
Sure. I think they should have Dr. Quintel's testimony read back to them.
I agree.
Specifically because I asked Dr. Quintel if he reached any conclusions as a result of meeting and evaluating Douglas Benefield. And those were the conclusions that Dr. Quintel said he reached. It had nothing to do with my asking him if it was based upon anything Ashley Benefield told him. And I think unless that message is sent, unless that's clear to them, then I think it's a terrible prejudice to the defense.
I'm sorry, what's a prejudice to the defense?
What's the question?
No, what was the prejudice to the defense? If what happened?
Prejudice to the defense is that they're being misled.
If we do what?
If we do not read back their testimony, read back his testimony. That way it doesn't have to be the lawyer's comments, it's the testimony of the witness, it's objective.
Judge, I think they're...
Okay. Here's another big difference between Florida and Massachusetts. And New York is the same way. New York is a readback state. If the jury wants a readback of testimony, they can say, we would like to read back portions of testimony because they have questions about it. In Massachusetts, during the Karen Reed trial, readbacks are not allowed. The jury is forced to rely on their notes and their own memories. They're not even allowed to ask for a readback. Or maybe they can. Maybe it's discretionary. But the Judge Cannoni in the Karen Reed trial said you're not going to be able to get a readback. And she made that ruling and instructed the jury on that before they even went back to deliberate. Florida, you can get a readback. And so Mr. Taylor's solution to this is let's just read back the recall testimony. That's what they're asking for. They want to know. They want an answer to that question, whether Dr. Quintal's observations of Doug being super controlling, an alpha male, I can't remember the other things, manipulative, whether that was based on his own opinion or things that Ashley told him. Taylor's asking for a readback. Here, obviously the prosecution thinks it's prejudicial. And here's what they say.
Are a couple options. One is the standard use your memory. I don't know if the court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
Okay. We listened to all of the jury instructions together, right? The ones that he instructed before closings, which was odd to me. So he instructed them on a whole bunch of stuff before the closings. Then after the closings, he instructed them on a couple of more things. Never once did he say, if you'd like a readback, just ask for it, right? Correct? Okay. The ruling is going to be because they didn't specifically ask for a readback, they're not going to get it. And I disagree with this because are we looking for the truth? I mean, really, like if this is what Vinnie Politan always says on his show. Oh, I don't want to know. I don't care about this. I don't care about that. I just care about the truth. This is about finding the truth. Okay. Is this about finding, because if this is about finding the truth, offer them the readback. Don't make them say the magic words to get their readback, and they're not going to give it to them. So listen to what happens here. It's from earlier today, if you're just tuning in.
All right, any final thoughts? Well, they clearly are not asking for a readback. They're asking a factual question. And I would direct both sides to standard jury instructions 4.3 and 4.4. 4.3 addresses answers to juror inquiries during deliberations. 4.4 is request for readback or playback or transcript of testimony. We've all done this long enough. This is not a request for a readback. If they want to read back, they say we want to read back.
Okay, we've all done this long enough. The jury hasn't. Maybe this is the first time they've ever served on a jury. Maybe they don't watch trials all day long like some of us do. Didn't it imply a readback? Apparently they didn't say the magic words, because here's the ruling.
They ask for testimony. It happens all the time. So at this point, the appropriate response is going to come from 4.3.
They ask for it all the time. They don't serve on juries all the time, these people. Shouldn't you at least instruct them that if they want to read back, they could ask for it? I mean, am I crazy? Because I feel like I'm being gaslit again.
What kind of name? Wonderful. Wow.
Why are you doing this to me, screen? Why are you doing this?
Judge, my concern, Your Honor, is that we're just assuming they know that they can ask for a readback. And I don't know that that's a fair assumption.
In your 400 trials, when has a judge ever given an instruction, hey, by the way, you could ask for a readback?
No.
No, I haven't either.
No.
Right. When in your 400 trials have you ever heard a judge instruct them that they can get a readback if they want one? And he said, never. And again, sometimes laws and procedures need to change. They need to grow. They need to catch up with the times. We can't assume that everybody knows, that every juror in Florida knows that they're allowed to ask for a readback. It's not in your instructions. You're going to admonish the attorney like he's an idiot, saying how many times in 400 trials did you ever hear an instruction that they could ask for a readback? They're just supposed to know the magic words in Florida, apparently. Don't offer it to them. Just send them back. and wait for the magic words.
But I don't know if they know that, and the question may be inarticulate, that maybe you could ask for a clarification of the question.
Your Honor, Judge, we don't object to 4.3. We ask that you.
I'm sorry?
We agree 4.3 is the right.
Yeah, that's the
Thank
correct
you.
response.
Yeah, if you needed us to agree, we do.
Okay. No, it's not even a debate. That's the correct response. It's 4.3.
It's not even a debate. That's just the correct response. We're just going to tell them, hey, you asked a question, so we can't answer your question. Go back there. And that's what they do. They don't offer them a read back. They're waiting for the magic words. Yeah, his demeanor is different, Elle, right? And this
Okay,
was only
I'm going to read you what I plan on telling them, and then you can comment on it how you want. This comes directly from 4.3. Members of the jury, I have discussed your note with the attorneys. You have asked the following question, and then I'll read it. If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it.
No objection.
Object.
Object for the same reasons that you want me to affirmatively offer a readback.
Yeah,
Okay.
just so we're clear, I think that what created that question was the plethora of misrepresentations that the state delivered to them in their closing argument, and that's the reason why they've asked that question.
preach. How many misrepresentations did we point out during that closing argument and the rebuttal especially? How many misrepresentations or outright lies or things that were never, ever entered into evidence, like Doug filing for sole custody? That never came in. Like Ashley trying to make Doug jealous or telling him that during, acts with previous lovers, they had choked her. And that's why he was sending her those creepy text messages about wanting to destroy people. That never came into evidence. He's right.
You know what? Tell me his name. It's not Quintella.
No.
Quintal.
Quintel,
Quin.
like William Tell, Quintel.
Okay, thank you.
And so that's what they do. So they call the jury back, and that's what they tell them. You're asking us to tell you a fact, and we can't tell you a fact. Comes the jury.
If I have not read you, and y'all can have a seat wherever you want. You don't have to sit anywhere particular. All right, y'all can have a seat. Welcome back. Members of the jury, I have discussed your note with the attorneys. You have asked the following question. 7/29/24, Dr. Quintella testimony, defense recall. Was his description with Doug based on his observation or what Ashley told him, i.e. domineering, super controlling, alpha male, over the top, not genuine, signed one of the jurors? If I have not read your note correctly, please clarify your question in a follow-up note to the court. I am not able to answer this request because it asks the court to resolve a factual question that is within the province of the jury. Your decision must be based only on the evidence presented in the trial and the law that I have given you. If you have any other specific questions, please send another note and I will see if I can answer it. Also, I don't want to know what's been discussed. However, it's getting to be almost 6 o'clock. If
If you have any other specific questions, and apparently that magic specific question has to be, can you please read back Dr. Quintal's testimony on defense's case in chief when he was recalled to the stand so that we can hear what he said?
You want us to order food. It is not, it's not steak and lobster. But we can order some pizzas and get some sodas and have them and brought to the room. If you want that to happen, also send a note through the deputies. All right, you may retire to continue your deliberations.
And that's it. So they went back to continue their deliberations, and I see we have at least double the amount of people back here now. So let's take a look, because the jury just came back and said they were deadlocked. The judge sent them back in to deliberate. So if you didn't see that part, here we go. They sent a note out about 20 minutes ago. Here's what the note said. Oh, that's before they came back. So first he discusses the note with the attorneys, and he says, the jurors sent out a note saying, we are unable to reach a unanimous verdict. And he said to the attorneys, what do you want to do? We might as well rewind it since we're here. Instead of me telling you, I might as well just show you again. Here we go.
All right, welcome back, everyone. We're back on the record in State of Florida versus Atty Benefield, 2020 CF 3014. I have another communication from the jury. I'm going to read it verbatim, and then I'll hear from both sides. Unable to come to unanimous verdict. Signed, juror.
Right. So that first question was almost 6 o'clock, and now we are at 10:15 almost p.m. And this question just came out, so I'm covering them both. I covered this first, then we went back, and now we're coming back to this for all of you that have just tuned in. There's 2,382 with you on this very impromptu stream. So if you wouldn't mind hitting the like button so it gets pushed out, that would be awesome. Law and Crimes poll that is up right now has 16,000 votes. It's got 50% guilty, 38% not guilty, and 11% voting for a hung jury. And I will tell you that usually law and crime polls are 80% guilty, so actually that's not too bad.
That's an easy one. It's been less than 6 hours. Keep working. But with this caveat, Your Honor, I think you should at least acknowledge to them, because I don't know that either out of politeness or a sense of intimidation, I don't know that they know they can ask if they can go home and come back in the morning.
Judge, and I think asking them about going home, coming back is definitely something that they also need to Allen charge before we make any decisions after that.
How do you give an Allen charge after 6 hours?
Yeah,
Exactly.
just go ahead and say your piece.
Judge, I didn't realize that there was any hour attached to an Allen charge. I just thought that once they said they were deadlocked, that you give them the Allen charge. But it is almost 10 o'clock, so they may want to go home and come back tomorrow.
All right, thank you both very much. As we all know, the Allen charge is a one-time thing. So my inclination was to bring them out, acknowledge that they've been working for almost 6 hours, well over 5.5 hours, acknowledge the time of the evening, and give them that option. And I'm not going to ask for them to vote. The way I do this is I'll explain to them, you've been working, we acknowledge that, it's late. If you want, you can go home for the evening, come back tomorrow fresh, and continue your deliberations. I send them back to decide if that's what they want to do or not, and then go from there.
Yes.
Okay?
Okay.
All right, let's bring them out.
And that's what he did. He sent them back, gave them the option, and they said they want to stay. They are staying. They're staying. So that's what we're doing. We're staying. They're staying. We're staying. Let's go back and take a look at Dr. Quintal's recall testimony, because this is what they're asking for. This is what they're not going to be allowed to have a read back on. But let's find out what we think that they're asking for and what we think they're talking about. Specifically, they were talking about the recall testimony, and they wanted to know that when Dr. Quintal testified with regard to his testimony about his Doug being domineering, super controlling, and alpha male, over the top, and not genuine, is this his opinion or is this something that Ashley told him? Let's watch the testimony for ourselves, since the jury won't be allowed to have it read back unless they ask the magic words. I like Neil Taylor a lot. I do.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
They're deadlocked, but they must be close because they asked to stay. So now we're going to go back and address the first question from earlier today.
Good afternoon, Dr. Kincaid.
Hi there.
Welcome back.
Thank you.
As a result of the counseling sessions that you had with Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
Agreed.
You go ahead and approach.
So they asked for an opinion. There's an objection. There's a couple of objections here, but let's fast forward to his testimony, which isn't really even that long. It's like, shouldn't we make a juror's job easier? Or should we insist that they know the magic lingo? Or maybe like during like jury selection, when they bring everybody in, give them a little list of generalities. Like, hey, if you're deliberating on a case and you ever want to hear any testimony back, you're allowed to ask for it. I know here in New York, they make you watch a video when you go in for jury duty.
Okay, Dr. Quintal, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working.
Now we're going over jury questions. So this was a jury question from earlier today. The jury's deadlocked. They were sent back, and they said they want to keep deliberating. So if you're late, I love when people come in late and then they're like, "Can everybody tell me what's going on?" I'm not going to address those questions anymore. You guys can address them in the chat, please. But I love when the other thing I love is when people come in here and they think they have rights. Oh, Scott, you missed it. You missed it, Scott. This guy was like, I have a right to be here, and I have a right to say whatever I want. Okay.
Working
Bye.
and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
Yeah, we can speed this up to
I don't
the
do-
right part. Good idea. Oops. See, but now look what happened. Now look what happened. Now I got screwed up. Oh man, why do I listen to people? If you're just joining and you don't know what we're doing, the jury is deadlocked. They were sent back. Prosecution wants an Allen charge. Defense is like, what are you, crazy? They've only been there for 6 hours. They're not getting an Allen charge right now. And so they came back with a question earlier today about Dr. Quintal's testimony. So we're playing it again because they won't give the jury a readback unless they ask the magic words. So let's get to the
I'm going to
point.
use the DSM frequently. I'm going to understand.
Have you in the past, or do you, in this particular case, did you, counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple, and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
Okay, then they approach again. So we're going to get his opinions on Douglas Benefield, and this is what the jury
Deviation,
wants to
Dr.
know.
Quintal. Tell us what degrees you hold.
So I have a
All right.
bachelor's.
Then they get into his qualifications, and then they're going to get into what he thinks about Doug Benefield.
Plugging the memory, so end versus where it's been stuck as happening, which on. I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, you're going to. I did, yes.
Okay, here's the question.
Both Doug and Ashley Benefield.
I did, yes.
Your Honor, I would tender Dr.
Okay, then he admits it. He says he can testify as an expert.
Yes. Okay. And how long have you worked now?
Do you want to voir dire the witness?
She voir dire's the witness, but he's eventually allowed in.
Was what?
We're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
It's hard to hear.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested, despite conversations with some of the disparaging things that Ashley had said to him. He was very much
Very clearly, based on my conversations with Ashley and Doug, these were my conclusions, right? This is important. This is what they want to hear. They haven't asked for the readbacks. They're not going to get it.
still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusions with respect to him being a real alpha male?
Alpha male.
Do you recall?
I would say that Doug occurred as somebody who was very built and well put together. And yes, I would say that he would fit the stereotype of an alpha male, in my opinion.
In my opinion, alpha male, in my
Did you
opinion.
conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Ding, 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 ding. Isn't the jury
Did you
entitled
reach
to
any
the
conclusion,
actual
Dr.
testimony?
Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Overruled.
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Godly.
Yes, I think it was over the top.
Over the top.
Right, and
That's
did
his
you
opinion.
reach any
Over the top.
conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
His opinion. Not that Ashley told him that. Right? Do you think it's important? Do you think they should get the readback without asking for the magic
Did
readback
there
words?
come a time when you
I can't. There's nothing I can do. This is Court TV's volume. So there's nothing I can do. That's why the closed captions are on.
inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of
Why he would want to stay with her. All right, let's go. I mean, there's movement in the courtroom. We just saw Eva walk in there. Hang on. I don't know if it's an actual verdict, but just saw Eva walk in. Where did you guys hear it was an actual verdict? Or did they want to go home? There's no volume up. So in any event, he does say that those are his opinions based on his conversations with Doug and Ashley. But then on redirect, it got on cross, he said something a little bit different, that, yeah, this was based on my conversations with her and with him, some things she told me. So it was a little wishy-washy. And that's why, don't you think the jury should be entitled to hear it? If that's really what they're stuck on, don't we want the truth? Don't we want them basing their verdict on what's actually happening? I mean, the actual testimony. People are saying verdict, but we're here. We'll see. I agree, Barbara. It doesn't seem right. It's an important question they need to know. They do need to know, in my opinion. All right, law and crime poll. 15 minutes ago. The vote is closer, 43% guilty, 34% not guilty, 23% hung jury. What say you, my friends? They haven't stopped the clock. So where are you guys getting the idea that there's a verdict? Let me just say. Are we behind a little beat or two? We are on real time. Court TV says verdict. Would they know? I guess they would know because their cameraman is in the courtroom, camera person. So we're just waiting. Is there a verdict? We don't know. Somebody says there's a verdict, but who knows? This is live. We're live. Everyone's back in the courtroom, so we're going to have to, we're here for it. I agree, Joanne. Part of jury instructions should be to tell them they can get readbacks of testimony. Jeez. All right, long crime. We're watching it. We're here. We're here live. Don't worry, my gosh. You guys don't worry. We're here for it. Connie, I'm so glad you're here too. I can't believe they reached a verdict tonight. Like I really did. I really thought this was going to go into tomorrow. That's what I really thought. And here we are waiting for it together. Got to change the title of the stream, right? All right. We're waiting, but since we were talking about it, let's talk about what the Allen charge would have been. It is found in Florida Standard Jury Instruction Criminal 3.06, which reads as follows. I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room, then taking your turns, tell each of the other jurors about any weaknesses of your own positions. Everybody's coming back, so I'm going to say we're actually going to get a verdict tonight. Like maybe like right now. Ever since somebody pointed out that they reminded you of the evil stepsisters from Cinderella, I just can't unsee it. I just can't unsee it. Nancy Jo says they don't want to come back tomorrow. Thank you. I am Titanium for the 20 for thanking me for coming back. Of course, we've been through this much so far together. Ashley, thanks for the 5. So glad I'm here. Why wouldn't the defense want an Allen charge? Isn't it good for the defendant normally? Not right away. They've only given it 6 hours. The defendant would rather have an acquittal. Laura, thank you. I assume you figure out what's happening. We are waiting for the verdict. As Collier Landry would say, oy vey. Thanks, Laura. Thanks, Shoshana Grace. In my experience, I don't even want to jinx it, so I'm not even going to say. I'm not even going to say. Thanks on top. Thanks, Brandy, for coming a new member on top for the super sticker. Mary Coppola, Judge in Hopkins v. Maya trial was great in Florida. He allowed read back and all attorneys participated. Yep, I remember that, Mary. Remember they would read it back together. Some of them would act out parts. Thank you, Sherry, for coming in with the super sticker. I appreciate you. And Mo, you as well. Sean Duncan from Australia, thanks for the 10. Ashley's testimony decided it for me. It was real and it was visceral. The prosecutor was abusive and re-traumatized her. A lot of people in my chat felt that way. Brandy Johnson, thank you for gifting a membership. You're so kind and generous. Cindy says, love the channel. Glad I found you. I'm so glad you found me too. Thank you, Cindy. Brandy gifted a membership. Did I say that already? If not, thank you so very much. Rules and a jury orientation state specific. Yeah, that's what they should do, right? When you go in for jury duty. It's Eva Benefield, Doug's daughter from his second wife, Renee. Thanks, I gotta know. Waldo Butters, YouTube live stream trials and availability of law enforcement body cams are shining a bright spotlight on our flawed justice system. Thank you, Waldo Butters, for the 5. Amy Beth, thanks for the 10. Appreciating my mods and me for going live tonight. I don't even know if I have any mods. Do I have are there mods in the chat? This was so I just went on. And look, there's 3,500 of you here. So if you could hit the like button, that would really help push us out. That would be amazing. So thank you, Amy Beth. Hockey Mama became a new member. Oh, look, I have my Rangers shirt on. Let's go, Rangers. Well, it's not hockey season right now, but I'm also a hockey fan. If you know, you know. Amber says, so frustrating when the truth is right there to contradict the prosecution's closing statements, and yet they can't hear it because they weren't explicitly asking for reading, even if it was inferred. Agreed. I agree. KJV, not guilty in under 7 hours. That's KJV's prediction. Elaine says, I can't believe not guilty, compromised in 20 minutes. It has to be not guilty. It's not 20 minutes. It's been 6 hours and 20 minutes. We don't know yet what the verdict is going to be. That's why we're waiting. Kelly says, with them wanting a readback of crucial testimony, then saying that they're deadlocked, and I'm not sure how long it took to come back with a verdict. Crazy. How long since they said they were deadlocked? That was when they were at about an hour 47. So it's been over 5 hours, maybe? Less than 5 hours.
We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I've been informed there's a verdict.
There's a verdict.
Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact, our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected, even if you don't understand it or don't agree with it. Are you ready to bring in the jury?
No outbursts. Here comes the jury. Waiting for the verdict if you're just joining. Jury has reached a verdict in something like 6.5 hours. We are in Manatee County, Florida at the Ashley Benefield trial, and the jury has reached a verdict. We are waiting for the jury to come in. Thank you, Tara Jean. Thank you, Sarah and Schwackenhara. warriors, take a deep breath. You are strong, you are loved, you are here. Laura Bronson, thank you so much for the 50. Thanks for doing the late shift with us. You're the best. You guys are the best.
All
We're
right,
here.
y'all can have a seat. Members of the jury, I understand you have a verdict. And we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form.
Here we go. Incoming.
All right, the verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
Here we go.
In the Circuit Court of the 12th Judicial Circuit, Canyon 4, Atty County, Florida, the State of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day
Guilty.
of July, 2024
Manslaughter.
at Bradenton, Manatee County, Florida. Cheryl Foreperson.
Would either side like the jury polled? State?
No.
Defendants?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Wow.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices. And please make sure that your notes stay with the deputy. They're going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you.
Guilty. The jury has found Ashley Benefield guilty of manslaughter, carries a prison term of up to 15 years.
All right, you all can have a seat. The jury is out. State.
Judge, I would ask you to remand the defendant at this point.
Remand her. They want to send her
She
to
has a right
prison.
to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do it to PSI.
I think we'd prefer to have PSI.
I'll sign an order tonight for that. It's a late in the evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that the Younghans, I know that the court is familiar with the standard.
Pre-sentencing investigation.
They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benefield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here. Her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghans decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Ms. Benefield to bond, continue her on the same bond, in fact. And if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the second district. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years.
I thought it was 15.
While this defendant may have appeared at every court hearing. She was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny bond.
She says it's up to 30 years.
Ms. Benefield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing.
Cuff her and take her out of the courtroom. Is her mother there?
All right, the court will stay in recess until we get a sentencing hearing set up.
Thank you, Your Honor.
I trust Your Honor will issue a written order on the bond.
The bond?
Yes.
Yes. If it's required, I certainly will.
If you're just tuning in,
Thank
Ashley
you. Thank you, Madam
Benefield
Clerk.
has been found guilty of manslaughter, facing up to 30 years, apparently. She has been remanded into custody. She was handcuffed and taken out of the courtroom despite her attorney's plea for her to remain on bond. She's facing up to 30 years, and they are going to have to. She goes to jail immediately. Do not pass go. PSI is a pre-sentencing investigation. Thank you, Pierre, for the swear jar. I'm shocked and mad. Something must be done. Thinking. That is it, my friends. That is all. That is where we stand for tonight. Thank you for hanging in here with me. Unfortunately, I have to go right now. But it is up to 30 years in prison and a $10,000 fine. Thank you, Lauren, for looking that up for me. A lot of you think the jury got it wrong. We're in shock and horror. And that is not the ending that so many of you wanted or hoped for. But that's it. Ashley Benefield has been remanded to prison. Sentencing date to be set. Thank you for watching this trial with me. I appreciate each and every one of you. Stay strong. The National DV hotline number is 1-800-799-7233. Thanks, mods. Be cool, be kind, be classy. Hit the like button. Thanks. You're warriors. You are warriors. You got this. Peace.